asked us to record these sessions. So let me just start with a little bit of an overview. We're hoping to, over the next 3 sessions, keep them all under an hour and talk a little bit about estate planning and estate planning choices that are available for you and your family and your friends. And also it's going to give you, we hope, some background information in terms of if there's matters that relate to file issues as well. The idea is to talk about some of the basic estate planning techniques this week. Next session is going to be on advanced estate planning, and the third session is going to be on life planning. Just while people are just coming online before we start, can everyone mute? Just we're getting a little background noise. That would be great. And all 3 of us practice in the area of estates, obviously, and Suzana and I more focused on the contentious piece, but we also do a lot of work in estate administration and obtaining probates, and Jordy is our king of drafting. So we're going to have 3 different perspectives throughout the sessions. Let's just jump right into it then. In terms of what we want to accomplish today, we're hoping that you'll leave today knowing a little bit more about either whether you've done a will or you haven't done a will, what is in a will, what was accomplished by creating the will, and also with a power of attorney, and give you a little bit of a granular idea of what it goes on in terms of how things unfold on your death through the use of a will, and how things unfold through the use of a power of attorney. Just starting, Suzana, at the high level, the key components of a will. What are we generally working with in terms of issues that the person is going to want to have sort of top of mind as they come in to give you will instructions?
Thanks, Ian. Well, we all know that the purpose of a will really is to distribute your estate once you're gone. So you want to be able to have some control over your lifelong accomplishments and what you've been able to create in terms of an estate, and figure out who you want to share that ultimately with. And so one of the key components is, of course, figuring out who you want to leave your estate to, in what proportions or what gifts or what amounts, and ultimately who's going to carry out your wishes for you when you're no longer there. So 2-part thing in terms of, figuring out how you want to distribute your estate, and then secondly, who you're going to entrust to follow your instructions to carry out those gifts.
So Suzana, just at the high level again, what's the difference between a will, a power of attorney, and then finally a trust?
Well, a will speaks from the date of death. So it talks about how you're going to distribute your estate once you're gone. While you're alive, if you were to become incapable, then you would need possibly a substitute decision maker who's going to help you with either your finances or your property or your personal care decisions when you're no longer able to make those decisions yourself. And those would be powers of attorney that you would appoint for either property or personal care to be your substitute decision maker when you can't make those decisions and you're still alive. And then finally, a trust is an arrangement, a relationship at law, basically, where you're choosing a third-party trustee to hold the assets in trust for the ultimate beneficiaries of the trust and those people that you want to benefit from. So you're putting it in the hands of someone else to do, once again, what it is that you want done with those assets when you're not dealing with them yourself.
All right, and just put you on the spot with the last point then, before we move over to Jordy. What happens if you die without a will? What is it? Does it really matter? What's the big difference?
That's a great question, Ian, and it's one that I think actually surprises a lot of people who aren't, delving into this on a daily basis the way that we do, because the statistics in Canada are shocking that only about half of Canadians have a will. And when you think about the financial repercussions that come about if you don't have a will, it is quite surprising, because if you die without a will, your estate is going to be distributed according to some statutory scheme, which may not necessarily be what you would have intended had you taken the time to prepare a will. And one of the biggest surprises there that people find is that a common law spouse, so someone who is not actually married, is not going to become a beneficiary of your estate if you haven't created a will, unless you take some advanced planning steps.
Yeah, that common law twist is something that many people miss out on, and think people that they've had a long relationship but they never were married, and they think that it would just naturally come to them. It turns into a nightmare, which we'll talk a little bit about in the third session. All right, so that's wills, that's the overview in that regard. But powers of attorney then, why is that an important document at any age and any stage in your life, Suzana?
Well, because if you don't have the authority, or you're not, no, sorry, the ability to make these decisions on your own, someone has to make them for you. And it's not automatically going to be your spouse or your common law partner or even your child. While you're alive, you want to make sure that you're choosing the ultimate substitute decision maker who's going to make these decisions for you when you no longer can. And if you don't, then some family member or some friend or some individual is going to actually have to go to court in order to obtain a court appointment to become your substitute decision maker. And as you can imagine, that's going to put a whole bunch of complexity, delay, and expense at the behest of someone who's going to try to otherwise be able to assist you with either your personal financial issues during your lifetime or your personal care decisions and things that need to be made when you can no longer consent or refuse treatment, or those kinds of decisions have to be made on your behalf.
Okay, so one of the things that I've always done, and obviously being born over 30 years in this area, I've got a little bit of a skewed perspective, but each one of my kids, when they turned 18, in the old days, you would go fight in the army, or in the old days, you used to be able to drink. Now I make them sign a will and power of attorney as soon as they turn 18. And I mean that in a joking way, but also in a serious way. The will doesn't matter so much because they don't have anything, but the power of attorney document is that important in my view. It is the cheapest form of insurance on looking after your affairs when you become incapable that exists. And I just can't harp enough on the importance of getting a power of attorney, a valid power of attorney for property in particular, as soon as you're able. All right, and Jordy, now let's start with you, and we're going to pick on you a little bit now. The idea of will planning, and the idea of coming in to see the lawyer and give your instructions for a will, it can seem a bit daunting for many people. And in fact, as Suzana says, half of adults in Canada don't even have a will. And it's not entirely because we're lazy and cheap. It's more than that, isn't it? And so the will planning aspect of going to see a lawyer and not knowing really what you're going to have to know or what you have to say or what you have to think about. Let's talk about some of the things that we'd want to know and to think about, so that going into the will planning step, we're much more informed. Because sometimes, and I'll say this not of you, but sometimes I think lawyers can be criticized. They'll do a will, they'll take instructions, they'll take a bunch of notes, they'll look up and say thanks, and we'll send the document to you. It's about 30 pages long, which you'll never be able to read or understand. You'll sign it, and you'll come home and say, yeah, I have a will, but I don't really know what I did. So let's talk a little bit about, give us a little overview of the will planning process, if you could.
Right. Thanks, Ian. It's a pleasure to be here. So when you're setting about to do up a will, you're gonna really need to address a couple of information areas. So the first is biographical information: who you are, who's in your family, what relationships you have with those people, any special circumstances about where they might reside or what kind of citizen they are, those kinds of things, just in general terms. And the other aspect is to get an idea of what sort of assets you have. And that's important for the advisor, for the lawyer in preparing your will, and for you as well, in coming to terms with what sort of decisions have to be made about certain kinds of assets. So, if you've got a home, how that's going to get dealt with. If you've got personal effects, household contents, furniture, antiques, whatever, how those are going to get dealt with. And the other part of it in gathering that information, and why it's important for you and for the lawyer, is to look at sort of the impact of tax, of other aspects of the amount that's going to beneficiaries, which might also indicate sort of how you want them to receive it. And we'll talk a little bit about that down the road. So I'm always surprised that clients, when we sit down and we show them, like, this is what you have to give away, they're like, oh, I didn't realize I had that much, because often they're not thinking about, you're not thinking about what kind of insurance you have, life insurance you have, or what you might inherit from your spouse, or those kinds of things. So it's a worthwhile exercise, and it also makes it easier if, God forbid, anything happens for your administrators of your estate and your family members to know what assets you have and where they are.
All right. Well, so Jordy, let's talk about, give us a lesson on what we can expect then if we were going to go to do a will, certainly with you in particular, because we'll pick on you and Suzana in terms of what your practices are, and what you can expect in terms of process, timelines, those kinds of things, and work through the sort of a mock will creation.
Sure. So I'm going to share my screen if that's okay. For those who are on video. So this is, for anybody who's a Modern Family lover, this is Claire Dunphy. I'm going to take you through Claire Dunphy's will as if you can put yourself in her shoes. But you can see in this case, we've built out quite a family tree, but often this amount of information isn't necessary in many cases, but it does give us an idea of who's out there and how they're related. And we can also ask questions and consider issues like, is there a disability? Is somebody disabled? Is somebody estranged from somebody else? Those kinds of things are important for the lawyer to consider. Is somebody being supported by someone else? Those are all important questions. So we can start with this kind of idea of who's in the family, and make sure that we're thinking about, the young people and the older people and things like that. And the next key element would be the list of assets. So, we often say, look, just use round numbers. This is just a snapshot that the lawyer is interested in. Really, it's just a snapshot of what you have at the time you meet. The great thing, as Suzana's pointed out, is that a will is automatically updated. It speaks from death. It kicks in when you die. And if it's drafted properly, it's going to cover everything you own when you die automatically. But it's helpful for the lawyers to know what's out there so that they can properly address different kinds of assets, as I've just said before. So what we try to do is gather a list of the assets that that our client has, and we look at what the income tax implications are, as well as another tax, what we call probate tax, that gets triggered on death in many cases as well. So, bless you, Ann. So this gives us, and it also gives the client, for you who's looking at this, oh my God, here's all my assets, here's the tax, here's what's going to get left over at the end. And people are often surprised at what they have. So that's sort of how those two components come together. And often what your lawyer will want is for you to fill in either a paper questionnaire, or nowadays more and more of us are using online questionnaires to gather this information in advance of the meeting, so that we can have a productive planning meeting. And the caution I give my clients is, don't spend a lot of time on this. I don't need to know that you've got, your Dodge Caravan is actually worth $8,455, because by the time we draft the will, it's actually probably be worth less, or it'll be changed in any event. So just give us rough numbers and rough, ideas of assets. That's what we sort of need from that. Ian, maybe I'll just take people through the next sort of how.
Yeah, just to pause on that. When you say rough, and I totally hear you loud and clear, giving a rough idea, but it's the categories that matter, right? And Suzana, you see this often in situations at the will planning stage, but at the litigation stage, when the nature of the asset itself can drive the litigation or the problem. And so the categorizing of even if you haven't got the last financial statement of well, for example, what would you run into, Suzana, where you're anxious at the intake level to make sure that the categories of the assets are identified?
Well, I think ideally you just want to make sure you've gone through a checklist to consider everything that you possibly do own because there could be specific consequences that come from a particular category, as Jordy pointed out, that may have a huge impact on your estate otherwise. And ownership and legal ownership is particularly important when it comes to things like corporate shares, for instance. If you have a corporation and there are shares of that corporation, who is the actual owner of those shares? Is it you personally, or is it someone else, or is it a family trust, or is it some other corporation? And delving right down into the actual ownership aspects of things can be very important from a litigation perspective, because when we're trying to uphold these wills and these intentions of individuals, if you don't necessarily own something, well, you can't give it away. And so from that perspective, it's important that we really delve into how it's being held and what consequences can flow from whatever arrangement that ultimately is. Also, from a litigation perspective, one of the biggest challenges when we see will challenges come about is that the individual wasn't capable, that they didn't know and appreciate, which is the legal test, know and appreciate what you own and the extent of your assets. Now, it's not going to be specific, like Jordan says, right down to the dollar, but it is, very broad-based. And so you want to make sure that you've got a good understanding of that, because it helps you from the drafting perspective, make sure that you've got a client who is capable and whose will hopefully will withstand any challenges based on capacity.
Okay, so Jordy, you were looking at a specific asset, for example, the family cottage. And maybe you could use that illustration. Many people, we're going to talk about some of this in a bit later in the podcast in terms of, the seminar in terms of the breakdown, but you had the cottage up as an illustration.
So this is another reason why the lawyer is going to want to know about all of your assets, because, for example, certain assets have a mini will attached to them. The way you own property can be a mini will. In this case, I'm showing you that Claire and Phil own this cottage jointly. And that's more than just an ownership. It has a mini will attached. As I always describe two people who own something jointly, if this pen is owned jointly by these two people and one dies, they literally just fall right off title, which leaves the other one as the sole owner. So the person who dies can't say in their will, oh, give my half of the pen to John, because when they die, the instant of death, if they own it jointly, they have no right to give it away. It's owned by the other owner. And so that's why, as Suzana says, the lawyer is going to be very interested in knowing, how certain assets are owned, because they can't be given away in a will in some circumstances if, for example, they're owned jointly. So
it can be frustrating for the client when they come in, because you tend to sometimes they sort of wonder why you have to ask all these questions. And that's a good illustration of why you want to ask that question. But then goes beyond that. And a joint ownership, we're going to talk a little bit more near the end of this, but is an interesting one, because many people think they know, but they don't know. It was 20 years ago they bought the cottage. They're pretty sure it was this, it was that. What do you do in that situation with your clients when there's some uncertainty as to the ownership of a major asset like the house or the cottage?
Yeah, so I would ask the client to agree that I can just do a quick title search to make sure. That will confirm how the property is owned. And it's worth the $20 in my view for the client to instruct me to do that, because it's very simple, it's very fast, and they'll know. Because it is so crucial, especially if it's a home or something like that. It can have a huge impact. I mean, if as an example, this cottage is worth, in Toronto, if the cottage is worth $1 million, I mean, ownership can affect, $15,000 worth of tax, and that we could save easily depending on what we do and how it's owned. And so little things like that can really have a dramatic impact, and that's what the lawyer will probably ask, to just confirm that.
Right. So sometimes our questions are worth asking.
Occasionally, I hope.
All right. Okay. So then, Jordy, let's move on then to the sort of, I would call this is the teaching moment, and then I'm going to ask Suzana just to comment on the model as well. But Jordy, why don't we walk through this, because I think this is a fundamental part of any good will instructions for anybody, and no matter what wealth. And just coming back to that, I mean, look, most of us can go in to see the lawyer knowing you got a house, you probably have a RIF or an RSP, you probably got some investment account, and you might have a TFSA. After that, who knows, right? And so the most of us are sort of in that ballpark. So this works for that ballpark, and it also works for wealthier clients. But let's stay in our ballpark for this description.
Sure. So, you know, if you were meeting with me, I usually start with this, and I say, you know, I'm going to teach you everything I know about estate planning, and it takes 3 minutes. It's kind of sad, but everything you really need to know, I can sort of summarize in the next 3 minutes. And the way a lawyer will sit down with you and plan your will is to break it down into 3 scenarios. So assuming that you're married and you have kids, let's assume that. They'll say, okay, what do you want to do if your spouse is alive when you die? What do you want to do if your spouse is not alive and you have kids alive? And God forbid, what happens if everybody's gone? And those are the 3 scenarios. And the lawyer will take you through each of those 3 scenarios. So if you're preparing for that meeting that you're going to have with the client, you might want to think, okay, what do I want to do if my spouse is alive? What do I want to do if my spouse is not alive, but the kids are alive? And what do I want to do if everyone's gone?
And just stop there, Jordy, for a second, because that is such a fundamental point, that coming back to the daunting task of giving instructions and doing your will and getting the time and the courage and the money up to pull this all together. The fact is, there are only 3 decisions that you're making, 3 different variables that you have to consider. It isn't that complicated. You know, the common law jurisdictions, it really isn't that complicated. So I just want to highlight that, because these scenarios are, if you've got them sort of top of mind, it brings the whole process into much more manageable, digestible steps.
Yeah. And that's what we're trying to do with this model, Ian, is to try to make it simple. And you'll see it's quite simple for decision making. And we're going to go one scenario at a time. And then, you know, we've been drafting, wills have been being drafted for 500 years, and we've still only been smart enough to come up with 2 options for you when you want to make a gift to somebody. And the first kind of gift is what's called an absolute gift. It's the simplest. And that means that whoever you pick as the beneficiary gets what you're giving them immediately when you die, with no strings. And they can do whatever they want with it. So if I give $50,000 to John, when I die, John gets $50,000 on my death with no strings, and he can go out and spend it all however he likes. He can give it away to somebody I don't like, or he can make a will that says, you know, the 50 grand that I got from Jordy, I want that to go to Susie. And even though I really didn't want it to go to Susie, he can do that. And the only other option, so we have the absolute gift, and the only other option you have is called a trust. And you know you want a trust if you use the word but to describe the gift. So if you use the word but, then what you've just said to yourself is, I don't want an absolute gift, I want a trust. And really, a trust is used for 2 main reasons. One, you want to control what a beneficiary can do with the money. So I want to say that you can use the money for certain purposes. Or I want to say, for example, I want my spouse to be able to live in the home, but when she dies, it goes to the kids. That's an example of control, trust used for control. And the other reason people classically have a but is to protect a beneficiary. I want my kids to get the money, but not till they're 30. Okay. Those are 2, that's for protection purposes. And that's basically every time you make a gift to anyone, you will ask yourself, is there a but or not? And that really is it. That's the key decision there. I don't know if you want to jump in there.
Yeah, no, that's great. Suzana, just in terms of the trust arrangement and the simple but piece of it, do you have any comments in terms of when would you want to consider it in the form in your will, and what type of scenarios are you going to be watching for the trust to surface?
Yeah, like Jordy said, I mean, it really is used for 2 purposes. One, the control, and the other one, the protection. And I see it mostly when we're looking at litigation over trusts that are contained within wills. It's over some beneficiary who's not necessarily pleased with the fact that there was a but and that their gift is not outright. And so when we have, for instance, minor children, and we're doing part of the planning process, we're going to want to consider, do we want that money to be available to this individual as soon as they turn 18, which is what the law would otherwise provide, or do we want to build in some protections? Not necessarily because we don't trust our children or because they're spendthrifts, but because they're young and they're going to be faced with a situation of loss, with some parent having been gone without the guidance and the opportunity to have someone protect them. And so we build in these mechanisms in our wills so that we can do that. If we have, for instance, disabled beneficiaries who are members of the family or people that we want to provide for, a trust will also allow us to do some planning to avoid the result that might otherwise come about, where they would lose perhaps government benefits that they would be entitled to otherwise, but for the fact that we've left them a gift that disentitles them. So as part of the intake process and as part of our logic tree that Jordy set out here, we're delving into these kinds of considerations to see what kinds of planning makes most sense so that we can maximize ultimately what the individual is going to receive at the end of the day.
Okay, great. Thanks, Suzana. Go ahead, Jordy.
I just wanted to make a point. Sometimes you get, remember I described that joint ownership? So sometimes you get the situation where people own something jointly and one of them says, yeah, I want to give my half to so-and-so, and I say, look, there is no way to add a but to a jointly owned property, right? You just literally, when you die, you fall off. There's no but allowed. And that's a fundamental decision, about how you own property. Because we do see buts, and we can't do it if it's jointly owned. So I just wanted to draw that back to that, how important really ownership is.
But Jordy, I couldn't resist another but. Tell me what your practice is, generally speaking, we're staying in the realm of the real world in terms of people who are doing wills. What is the, with regular wealth, we'll call it, what are you telling your clients in terms of timelines for the trust terms for their younger children? So kids are in their teens, they're doing a will, gift over to the husband. If they both die, the kids are going to end up with a lot of money if you're not careful. What are some of the parameters that you're typically recommending for those trusts?
Right. So, trusts can be seen as very complicated. They're actually quite simple, and pretty much every trust works the same way when we're talking about money. And it's really a question of sort of 3 or 4 factors. But the first factor that you've just raised is this duration, which is how long is the trust going to run? And the example that I always say to people is, you've got younger kids. If you died and they were 50 years old, would you be okay with them getting their money with no strings? And often people say, yeah, of course. And I said, that number, whatever number that is, where you'd be comfortable with them getting the money with no strings, that's the duration of the trust. So if you said to me, okay, I'd be okay with them getting their money at 30, great, then that's the duration. You can pick an age, you could pick an event, you can pick a lifetime if you don't want them ever to get their money without any strings. So that's really the first issue, is that duration. And most commonly, it depends, of course, on the size of the estate, but 30 is not an uncommon number, because the point is that it's not that they won't get any money before 30. 30 is the age at which they will get their hands on it with no strings. And that's, again, the duration. But before 30, or before the end of the trust, whatever age you pick, there's 2 ways that money can come out. One is you say to the person in charge of that money, called the trustee, you can decide how much money to give to my child at any point before the trust ends. So that's what we call discretionary. And that's most commonly, you don't put any limits on the trustee. Whatever they think is appropriate, they can give to the child. And the other is, sometimes people say, look, I want to give them half at 25 and another half at 30. That's a staged distribution, and those are mandatory payments. Why are they mandatory? Because at age 25, the child gets their half right now. You can't hold it back. It's mandatory. And that might be a good idea, that might be a bad idea, but it's going to happen. And so those are the two ways that that a beneficiary might get money. And there's lots of different options, and your lawyer will take you through those options. But those are the two main sort of categories of money flowing out during a trust to a beneficiary.
So, Suzana, let's talk about the rule against perpetuities.
I hope not.
Just kidding. Just kidding. Had to throw. These are pretty ad hoc. This seminar, so we're not working from a script. So no. I just wanted to ask you, Suzana, in terms of the planning from a trust standpoint, your thoughts and anything else you want to add. And just as an aside, this is obviously the one of the main reasons why you want to have a will if you have children, because otherwise, what I call is the Corvette effect. That your estate, if you both die and they're minors at age 18, they're all going to be getting a lot more money than they can probably handle if you don't have a will. So, did you have anything to add on the planning piece before we move on with our next part?
I think I would just indicate that the discussion that Jody's just had about, whether or not we're having discretionary payments, mandatory payments, some mixture or combination of both or neither, really underscores how important it is that the person that you leave in charge of your estate, who's going to be making these decisions, is someone that you trust. Someone who knows the family, who knows the potential beneficiaries, or knows what your wish would have been for those beneficiaries. Because, the exercise of discretion can so easily be challenged at the end of the day by the beneficiaries if the trustee's not acting, in their best interests or not acting in good faith. And so I think all of this just sort of underscores how important it is to pick the right person who can help you, again, effect your wishes through the trust and take care of your ultimate beneficiaries.
Okay, great. Over to you, Jordy. I know you were just open. Sorry, jump in.
Just to deal with that whole idea of the trustees, really. So that's the person or people who are in charge of that trust. And if you've given them the ability to decide how much to pay out before the end of the trust, they obviously have great power. And what I say to clients is you've got 1, 2, or 3 people that you could pick to do that. If you picked a single person to do it, you can do that. The downside is all the pressure is on them, and they have nobody to blame. If you appoint 2 people to be the trustees, then at least they can point to each other and say, well, I said no because I would have said yes, but he said no. The downside to having more than one person is they could disagree, in which case you've got a stalemate. And what you'll learn when you talk to your lawyer about this is that there's, for every solution, there's a problem. And then what some people do is say, well, I'm going to pick 3 people and we're going to have a majority rule. And that can work. 2 out of 3, for example, can make decisions if there's a dispute, but then there's logistical issues. And maybe next week or next session, we'll talk about sort of how you pick trustees and what kind of factors go into it. But it's obviously, as you can see in this situation, where they're going to have a lot of discretion about how to invest the money and how to spend the money, that picking the trustee is often the most important decision that you're going to make. And I think that's something maybe that we can discuss a little bit more next time. 2 other points I just want to raise, if I can, Ian, is when we use the but, right? You can come up with, after the word but, you can come up with anything you want, anything you can come up with. That could be the trust terms. You could say, look, you get X dollars a year, but only if this happens and that happens and this doesn't happen. So you can, I just ask my clients to just describe what you see happening, and then we can turn that into the language that we need to. And the last thing that lawyers are always going to ask you to think about, that many people don't ask or many people don't think of, is what happens to that gift if the beneficiary is not alive. So either they die before you or they die before the end of the trust. And that we call a gift over. And so that's something else that a lawyer will ask you to think about. Okay, if you wanted to give this to John, what happens if John's not alive? What happens to that money? Or that asset or whatever. So
and often that gift over, sorry, go ahead. Often that gift over is to minor children or great grandchildren or great grandchildren, sometimes not even alive, just so that you can keep the trust going. All right, well, just because next week and the week after that we're doing these, we have pretty heavy agenda, so we actually are going to talk a little bit about the appointment of executors this week.
Sure.
So, but maybe I could start that discussion. But I'm going to start that with you, Suzanne, in a moment. But I just wanted to make sure we'd finished your thoughts on the 3-2-3 model. If there's anything else you wanted to add there, Jordy.
Sure. So
then we'll come back to Suzanna on that part.
You bet. So the last thing that I'd like to explain to clients is, how does a will work? What does it look like? And this is what I would say a will looks like. It's a funnel. And when you die, everything you own in your own name that's not jointly owned goes through this funnel, goes in the top. And it's separated. So things that are jointly owned, or where you can designate a beneficiary, for example, an RSP or life insurance, and we'll talk a little bit more about that. Those go outside the estate, right? They don't go through the will. So those are those assets, but everything else flows through the will. And there's a couple of stages. There's filters for debts and taxes, things like that. That's gonna siphon off some money. And then there's this level called initial gifts. And initial gifts are things where there are a specific amount of money, X dollars, or there are specific assets, my piano, my shares in a corporation, my house. Those are initial gifts. Those come off the top, they're dealt with off the top. Whatever hasn't been dealt with there flows down, keeps flowing down into a big bucket at the bottom. And that we call the residue of the estate, or the balance of the estate. And that is divided into percentages, either 100% if it's one person, or smaller percentages if it's a group of people, because we need to make sure that we give away 100% of whatever flows down, because everything you own when you die is just going to flow right down through these into this big bucket. And that's sort of how a will works. And that's how we'll think about a will when we're sitting down and planning it, stage by stage. You'll think about what initial gifts you want to make, and then what you're going to give away in the balance of the estate. So
we go to Claire Dunphy's.
Oh, sure.
And just show what it looks like in real time in terms of the bucket. And then also just so you know, the session is tomorrow. It's not next week. I looked at my agenda too quickly. Karen is keeping me on track. It's tomorrow, and then the following Tuesday, October 13th. Tomorrow's at noon. But anyway,
sure.
we're gonna keep working through this, and then talk a little bit about appointments right after that. So go ahead, Jordy.
So let's just pretend you're the client, you're Claire Dunphy, and we're sitting down, we're planning. We're going to use that 3-2-3 model. We're going to ask you, what do you want to do if your spouse is alive? Well, certain things are going to go to your spouse because of the ownership. Remember, we talked about joint ownership. So the home is joint with Phil, for example, and so is the cottage. Claire, you're going to designate Phil as the beneficiary of RSPs, for example. That you can do right on the plan. So those are all assets that are going to go to Phil with no strings. And the next question I'd ask is, are there any specific gifts that you want to make to anyone, either an amount or an asset? Remember, these are the initial gifts. And you might say, look, I want the artwork to go to Alex. Sure, no problem. And I want my personal household effects to go to my spouse, Phil. Okay, great. So we've done that. And then what do you want to do with everything else? Well, how much is everything else? Well, in Claire's case, we could say we started with X dollars. We have X dollars joint. We have the artwork going to Alex. We have tax and debt and things like that. So we have, X dollars to give away. What do you want to do? Well, I want to do it simple. I want to just give everything to my spouse. That's often the most common approach. And so you say, okay. And I say, is there a but? And you say, no but. So we know we want an absolute gift. And there is an absolute gift of everything to the spouse. And that's just how you'd plan. You'd sit down and go through that. that situation. And the great thing is if your lawyer is using software, you can see the impact. So by doing this plan, you've saved $760,000, or Claire has, in income tax and probate tax of $60,000, just from the structure of what we did. Now, obviously, there would be more discussion with you when you're sitting down planning your will, but that's an example of how you might plan if your spouse is alive when you die. The second scenario.
What is it?
Yep.
Sorry, Jordy, just what does that look like though, visually?
So visually, if we were to show what that looks like, this would be the example of what does your will look like if your spouse is alive. So we have, you started with X dollars. We have these assets that are automatically going to your spouse. We have these debts and these initial gifts. And here's the big bucket. And it's all going to fill with no strings.
All right. Well, that's great. Just in the interest of time, I just wanted to do that illustration, sure, because that's the most common. Without getting too much, we've got an advanced planning session tomorrow, which we'll be able to work through some of that. All right. Can we just spend a moment now, Suzanne? I want to cover a couple things before we wrap up. One is the appointments. Now, Jordy has talked about that generally, but the appointment of executor, the appointment of a trustee of a trust, those two appointments, what are some of the factors that you want to have your clients consider before you put pen to paper on those?
I think I really start in with the complexity of the situation. So if we're looking at an estate trustee and who should be the one to administer that estate, we want to make sure that we've got an understanding of how complex that administration is going to be so that we can consider the alternatives. Is it going to be an individual who's going to administer this estate? Someone who's a family friend, what kind of individual would be ideally suited for that position? An accountant, perhaps, a lawyer. Or are we looking at a trust company kind of situation where we have a professional trustee, someone who's in the business of administering estates and can do the more complex things that perhaps one individual or even three individuals collectively would have a harder time doing? So just really understanding the nature of the estate, how it's ultimately to be distributed, what kinds of trusts are going to continue on, like how long will this administration take, are all things that I want to take into consideration when we talk about the alternatives in terms of who's going to help administer ultimately.
Yeah, and one not so tangible thought, but one that you've already mentioned this is so important to me is what are the dynamics? What are the complexities? It's not just about the business side of it. Who's going to be able to manage the relationships best? Now, that's a bit of a guesswork, but most of the time your client's the best suited to give you that choice. Yep. All right, and Jordy, do you have any other factors you'd like to consider in terms of this selection?
Sure. So I'm just trying to call up, but yeah, I mean, age is important. Because often people say, okay, I have this trust that's going to run for 30 years and I'm going to pick my father who's 84 years old. And I'm like, well, that doesn't sound like a great idea to me. So, here's just an example of some of the things that we think about it. But, obviously trust crucial, their ability, their experience, age, their ability to communicate with beneficiaries. Their willingness to act. You made a great point about relationships, something that, if you were filling out the will yourself, trying to do your own will, and you said, okay, I'm going to appoint my brother to be the trustee for my kids. It's important to recognize how that changes the relationship. I mean, rather than uncle, nephew, or niece, now it's trustee beneficiary. And the nephew has to go to their uncle and say, can I have some money? We've all seen Lion King, and I often joke that our profession is really one of two Disney films. It's either The Lion King with the brothers fighting and the nephew and uncle, or it's Cinderella and the evil stepmother and the absolute gift of the house by Cinderella's father to the evil stepmother, which didn't provide for her. So You know, these are really crucial questions, and they're the most important, and they require the most sort of concentration, thoughtfulness, and experience. What will work and what won't work, and you know, that's really worthwhile exercise to really go through all of that that stuff. So this is, by the way, just a draft slide. I just realized
That's great.
I sent it to. So anyway,
it's a good slide.
we're working
all right.
on it.
The last point I'll just make on appointments as guardians. Now I'm not there now. When I was much younger and doing wills, it was always the thing that would stop my generation at the point in time where they had young kids from doing wills, and I always get very frustrated with my clients. It's like, stop worrying about appointing guardians. I mean, it's a long shot moment. It's not, you know, if you can't decide, that shouldn't be why you don't do a will. Do your will. If you can't make that, you can always come back and solve that problem later. It's only a 90-day appointment. It's not carved in stone. But anyway, that was just sort of my bugaboo. Now that I'm much older, it's not much of an issue because none of my friends have young kids. But the appointments is a crucial basic step that we really like to have our clients thoughtfully considered. Last thing, and we're going to just spend a few minutes on this to wrap up today, is other ways of giving assets away. Now, Jordy, you talked about joint ownership, but Suzana, you mentioned as well beneficiary designations. Can you tell us a little bit about beneficiary designations and how they work, generally speaking, in the estate planning process, and where bumps in the road that you've seen have come along?
For sure, Ian. So when we're talking about beneficiary designations, we're talking about things like RRSPs and insurance plans, things where, you know, during your lifetime you own them, and then you get to designate on your death who gets them once you're gone. And those designations are great because they allow these assets to pass again outside the estate, so they're not attracting probate fees, and they're going directly to beneficiaries, so there's no delay after your passing. We don't have to wait for probate or any other of these complexities. We're basically just showing a death certificate, and the funds are being paid out relatively quickly to the designated beneficiaries. So they're an instrument that you can use as part of your estate planning process to simplify things, keep it outside of the estate so that it's not as complex. But by the same token, you can also designate your estate as the beneficiary of these instruments, so that if you need a funding mechanism that's going to be able to assist the estate at the end of the day with perhaps payment of taxes or capital gains or probate fees, there's a means by which we can use these as well to increase the size of the pot at the end of the day so that those payments can be made.
Jordy, just one, and we're not going to get too granular on this point, but our registered retirement savings plans and RIFs, there is a tax sort of twist that often many of my clients don't realize until I've told them. Do you want to just explain that one element of them?
Sure. So RSPs, just take that as an example. When you put the money in, you get a tax credit, right? You're getting to deduct it from your income tax. So eventually, the government gets their money back, and basically, if an RSP is designated or goes to a person other than your spouse, let's just leave that. There are other exceptions, but let's just say that that's the big one. If it goes to a spouse, there's no immediate tax when you die. However, if it goes to anyone else, a friend, a brother, an adult child, for example, it's as if you had earned all of that income in that when you die. So if it's $500,000 in your RSP and you pass away, it's as if you earned $500,000 plus any other income you earned. And so you're going to pay basically 50% tax on your RSP when you die, unless it goes to a spouse. That's why your advisor will sort of take you through the impact of, if you decide, oh, I want to do this, this, and this. One of the great things is that you can sort of demonstrate the impact of those decisions from a tax point of view.
And the important thing,
go ahead.
So I was just going to say, the important thing there is that the beneficiary, who's a non-spouse, so the friend or the adult child, is going to get the full 500, but your estate is the one that's going to be paying that tax at about 50%. So that becomes a really important planning consideration when we're trying to figure out what's left in the bucket and that residue pot at the end of the day.
Oh, and that's such a great point, Suzanne. I was on a call just before this with client, and I asked for the surviving spouse, lovely lady, and her son got the RIF, and she's like, so I got to pay the tax. My son got all the dough, and she was nice about it because they still like each other right now, giving time to brew maybe. But it was sort of a surprise to her, and it wasn't the fact that the tax hit and the funding of the tax hit on what is a product that most of us over the lifetime, have thrown some money into. It's a pretty important element of it. All right, last point, maybe Suzana, we'll start with you, and then Jordy. What's the difference between an inter vivos trust and a testamentary trust? And then Jordy, maybe you can talk a little bit about what planning tools you use for those two options.
Sure, Ian. The inter vivos trust is just a Latin phrase for lifetime trust. So it's a trust that's created while you're alive. So you're putting assets into the hands of a trustee who's going to hold them in trust for the beneficiaries. And it's done while you're still alive, and you can watch what's going on here. A testamentary trust is a trust that you create in your will. So it only comes to fruition once you pass away, and that trust is established in accordance with the terms of the will, with the trustee who's named in the will, and with the terms and the conditions that are otherwise attached to that trust, which again are going to be set out in the will.
Jordy, just a couple of comments on the planning piece. You're on mute, I think. We can't hear you.
Sorry. Trusts don't have to be that complicated. The sort of factors that we went through, those 4 or 5 factors, work for every kind of trust. It's the same questions that you ask and same sort of decision making. And yeah, I mean, the trusts and wills are common. The good thing is they pop up if and when you need them. So if the trust in the will says, there's a trust if your child is under 30, but the child's over 30, well, then that trust doesn't pop up when you die. It literally just pops up if it's needed. That's the great thing. These inter vivos trusts or living trusts are much more complicated in the sense that you're taking an asset that you own and you're giving them to a trust while you're alive. You don't, depending on what the trust says, you may or may not have access to that money. So it's a high level tax driven mechanism that most people don't necessarily need. It's much more common to see a trust in a will for, as we discussed, control or protection of beneficiaries.
Great. Well, thanks so much. And so we've got on tomorrow, we're going to talk a little bit more about some advanced planning. And that really is not that it's advanced, but more we're going to get into different scenarios. We've talked about basic estate planning and some of the considerations we want to look at. But tomorrow we're going to talk about what is this about probate tax and avoiding probate tax and how do we do it. Talk a little bit about maybe some cross-border issues, blended families and how to manage those issues and how to plan for that. And then planning for special assets like cottages and companies and things like that, digital assets and so forth. So please feel free, you can send an email to ihull@hullandhull.com if you have any questions that came out of today. Tomorrow we're going to have some more time for questions. We had a bit of an action-packed day today because we wanted to cover a lot in the basics piece of it, but we're going to have some time tomorrow on the chat line. If you have questions, please feel free to jump in. It's going to be at noon tomorrow. I think you've all got the Zoom site. And I can't thank Karen Wood enough for getting this all organized for us. We've really enjoyed it and look forward to tomorrow. And then the final one will be on Tuesday, October 13th at 1 p.m. But I'll remind you tomorrow after we do our seminar. Thanks, Suzana. Thanks, Jordy. And thanks, Karen.
Thanks, everyone.
Thanks. Bye.
Have a great afternoon.
Thank you.